Good morning, everyone. We're going to call the next case, People versus Dexter Taylor. This is a mini oral argument on the application. You each have 15 minutes. Mr. Branch, you may reserve time if you would like, but you'll try and manage that yourself. And we will get started with you.
Much.
You are, there you go.
Oh, I'm muted now. Let's see.
No, you're good now. You're good.
Good now? Okay, very good. Okay, I'm going to address the three factors that you mentioned in your order. And the factors were striking similarity, doctrine of chances, and harmless error. And I want to address them while also taking a look at some of the positions taken by the prosecutor in their brief. And the first thing I think we can look at is just what was the evidence of other acts in this case supposedly used for. One thing we know for sure is it wasn't identity, because the DNA established identity, and Mr. Taylor never denied having sexual contact with Miss Davis. Now, in the prosecutor's answer, they state that the striking similarity test here is a non-starter. And they take the position that other acts' evidence must be strikingly similar only when introduced to prove the defendant's identity as the perpetrator. Well, that seems a very curious position. That's certainly not what the Denson case says. Denson says, and I'll quote this, "If the prosecution's theory of relevance is based on the alleged similarity between a defendant's other acts and the charged offense, there must be a striking similarity between the other acts and the charged offense to find the other acts evidence probative and admissible." The other acts evidence in this case was relied on only for similarity. That's what the prosecution argued throughout and in their closing statements. He talked about the similarity of geography, weapons, and the perpetrator walking away. So the argument was entirely about similarity. If it wasn't about similarity and it's not about identity, the only thing left is propensity, which is saying he must have done it because somebody else says he did it before, and Denson tells us you can't do that. Now, the prosecution takes the position that the Sabin test should apply to establish a plan, scheme, or system. Now, this gets a little beyond the three factors that you asked us to address, but the Sabin test says general similarity between the acts is not sufficient. The prior act's evidence must indicate the existence of a plan rather than a series of similar spontaneous acts. So, exactly what motive, opportunity, and plant preparation scheme or plan does the evidence in this system prove? Mr. Taylor had no way of knowing that two lone females a year and a half apart would be walking down streets a year and a half away from each other. Miss Doak seems to have been there by accident. At the very most, this shows, as Sabin says, a series, only two, of similar spontaneous acts. There's no plan here. So even if you take the Sabin test, as argued by the prosecutor, it is still not sufficient. Now, regarding the actual factors used to show striking similarity, and these are as mentioned by the Court of Appeals also, the factors were, number one, geographic area. Well, we're talking kind of a three-way corner between Detroit, Melvindale, and Ecorse. Apparently, I don't know, I think the statement at the trial was about a mile and a half area we're covering. And we're talking two incidences a year and a half apart. That is not striking. I wonder how many CSC cases were reported in that area over that period of time. And I wish I could tell you, but what I found out is that those statistics, because they're so old, are no longer available. But I don't think that is a striking factor. The fact that there was two CSCs over that geographic area within that time period. Now, they also mentioned that Mr. Taylor approached a lone female in each case, but isn't that the MO in most CSC cases? I don't think I ever heard of anybody approaching a group of people and picking out a female victim. They also mentioned that the acts occurred in an isolated location. Again, this is the MO, I would think, in most CSC cases. You're not going to do it in anywhere that's not isolated. And they mention the use of a weapon, one being a pocket knife and one being a baseball bat. But again, this is a generic similarity in many CSC cases. These similarities are not striking. They are simply, I say, it's nothing more than generic. And I wonder, if you were a police detective and these two cases came across your desk a year and a half apart from each other, would it strike you they were related? I don't think it would. Some similarity, yes, but nothing striking.
Mr. Branch, I'm going to interrupt you
Yes.
and see if my colleagues have any questions, okay?
Okay.
Justice Zara.
No, actually, I was very much enjoying the argument. I thought you did a really nice job of presenting your case.
Oh, thank you
Oh,
very much.
I apologize. We'll get back to it if nobody else has any questions. Justice
That's
Viviano.
okay, I'll take compliments instead of questions. I don't mind.
Oh,
I'd rather.
yeah, right. Right. Justice
Okay,
Viviano.
doctrine of chances.
No. I didn't mean for you to start talking again.
Oh, I'm
No,
sorry.
but hang on.
Okay.
Maybe eventually, but let me just give everybody a shot. How about Justice Viviano?
No questions at this time. Thank you, Mr. Branch.
Justice Bernstein?
No questions.
Justice Clement?
No questions. Thank you.
Justice Kavanaugh?
No questions.
Justice Markman?
No questions. Thank you, counsel.
All right, now you get to keep going.
Okay, doctrine of chances. We have here, we're looking at the chances of a man having sex, either voluntary or involuntary, within a 1.5 mile area in a 1.5 to 2 year period. Now, I used a long quote in my brief, which I don't usually like to do, but it gives examples of when the doctrine of chances might be called into play properly. For instance, arson, that's the only time I've ever seen it, is in arson cases, multiple fires that somebody sets and then tries to collect on insurance. Also, an example given is a fellow who had 3 wives die in bathtubs and then got insurance. And it talks about lotteries, somebody winning the lotteries multiple times. Okay, these are not the same as what we have here today. Also, Professor Edward M. Winkelried defined the doctrine of chances as a large number of similar accidents will befall the same victim in a short period of time. We don't have any of that here. We don't have a large number. We have 2. We don't really have a short period of time when you consider the act involved, namely having sex. We have a man having sex 2 times within 2 years in a geographic area of about 1.5 miles to 2 miles. In addition, this is interesting, the Mardlin case that we talked about says that for the doctrine of chances, the similarity must be striking, the same as we previously talked about. So in those other examples with the lottery and the man drowning his wife in the bathtub, etc., those are striking similarities. There's nothing striking about the similarities in this case. Okay, and that brings us to harmless error. Now, our first position on harmless error was that this is preserved constitutional error. So Mr. Taylor is entitled to relief unless the prosecution can show the error is harmless beyond a reasonable doubt. Why is it constitutional? Well, it's constitutional because it deprived him of his due process rights to have a fair trial. Prosecution can't show that error was harmless beyond a reasonable doubt for one very good reason. And it's a very practical reason. Without that evidence, without Ms. Doak's evidence, they weren't able to convict Mr. Taylor in his first trial. Without Ms. Doak's, the jury never gets the image of Mr. Taylor armed with a knife sexually assaulting the pregnant lady. Without Doak's, there's no evidence at all of bad character or propensity, and that's really all the Doak's evidence demonstrated.
Mr. Branch,
Well-
can I interrupt you on that? Isn't it the case that even if everybody agreed with you about the 404B claim, the prosecution would be able to admit the new evidence under the 768-27B, the statute that now clearly permits that? And doesn't that create a problem for you in terms of this harmlessness argument?
Well, not really, because if you look at the very first sentence of the statute, they still have to get through the 403 evidence. Statute says unless excluded by MRE 403. And our argument there is, well, it is excluded by MRE 403. It is more probative than prejudicial. It is not substantial. It's just two instances over a 1.5 to 2 year period. So it is excluded by 403. 403 also, it's not really clear to me the way that statute reads, is a threshold level. So I think it is excluded by 403. It's also and not included by the subsequent rules of evidence. So that is our response to the statute. I was going to get to that next. So ultimately, what was the purpose of the evidence? It really only had one purpose, and that was to show bad character, to inflame the jury, to show he raped a pregnant lady with a knife. Now, why else, if that's not so, why was that characteristic elicited by the prosecutor? He points out at least 2 times that Miss Dokes was pregnant. What does that have to do with the case against Miss Davis? Nothing. It's just there to inflame the jury. It's used to get a conviction where previously in the first trial, they were not able to get a conviction. The jury never should have heard of Erica Dokes. It was a violation of Mr. Taylor's rights under state law. It was a violation of his constitutional rights to due process and a fair trial. This conviction should be set aside. Thank you.
Thank you very much. Ms. Summers.
Morning. May it please the court, Amy Summers appearing on behalf of the Wayne County Prosecutor's Office for the people. Other acts evidence does not need to be strikingly similar to the charged crime when the defendant's identity is known and the only issue that remains is what his intent was. People v. Sabin sets forth the proper test for common scheme, plan, or system evidence offered only to prove a defendant's intent, where the defendant's identity is known. Here, the evidence only needed to be sufficiently similar to the charged act in order to support an inference of defendant's pattern in raping women. The evidence was also admissible under the doctrine of chances in order to prove non-consent and in order to prove that defendant's intent was not innocent. The doctrine of chances relies on the premise that the more times an out-of-the-ordinary event occurs in relation to a defendant, the less likely that the defendant's intent was innocent or that the event was accidental. Here, the doctrine of chances asks, what are the chances that defendant engaged in a consensual encounter with the victim when not one but 2 women, neither of whom knew each other, both came forward claiming to have been violently sexually assaulted after defendant's DNA was found in both of their rape kits? The answer is it's not likely at all, and defendant's intent was to rape the women. Even if this court does find evidentiary error, the error in this case was harmless because the victim's testimony, if believed, proves a violent sexual assault occurred, and defendant's DNA proves that he was the perpetrator. Lastly, if defendant was to be retried now, the same evidence would come in, as Justice McCormick pointed out, under 768.27b. The statute was enacted after defendant's trial in this case, and it allows propensity evidence subject only to Rule 403. So to have defendant be retried now, only to have the same evidence come in at the trial, cannot be a miscarriage of justice and would not be an efficient use of judicial resources. I'm open to questions at any time.
Thank you very much. Justice Zara?
Questions?
Justice Viviano?
Yeah, thank you, counsel. Can you help me separate between the notion that the evidence that you're submitting about the prior bad acts, how we can distinguish between offering that evidence simply to show the defendant was a bad person and therefore he likely committed the second crime at issue in this case, or as you just suggested, how it shows how does it go to the lack of consent, the claim that the defendant's claiming that the victim consented. So if there's an intermediate inference there, can you tease out a little bit more or flesh out for me how the evidence supports that intermediate inference?
Sure. So under the 2 theories, the first is the common scheme or plan theory, and we're using the common scheme or plan to prove the non-consent. So the common scheme or plan is actually the intermediate inference, and we're using it to prove the defendant's intent, or here we're using it to prove that the victim did not consent to the sexual act. So you have to look at the relevance of the evidence. Here, it's here under 401 and 402, it's material. The material issue is consent. And you have to, the similarity that's required has to be enough in order to prove that, in order to make it more probable than not that the victim did not consent in this case. So when you have, when that's all we're trying to prove is that the victim did not consent, you could have two completely different incidents as long as neither victim consented, and it would still prove, it could still be probative of non-consent. For example,
you have to connect the prior act evidence to your allegation in this case, right? To the charge in this case.
Correct.
So the evidence is that there's a prior victim who didn't consent. Right?
Correct. And we also did have, there are more similarities than just that. I mean, it would still have relevance, I think, even if it was just two violent sexual encounters, even if the defendant didn't commit them in the exact same way. If they were both violent or non-consensual, that would be probative of non-consent. But here we have more than that. We have the defendant was targeting two women who were walking alone, that he used a weapon in both crimes, even though one was a knife and one was a baseball bat. He left the weapons behind in both cases. He isolated both victims. So we have even more than just the two non-consensual sexual encounters. But the level of similarity that's required, it depends on what we're trying to prove. So in this case, we're offering it to prove non-consent.
What I'm struggling with, I get that, I get all that. What I'm struggling with is, why does the evidence in the first bad act, the first assault, make it more likely that the second assault was done without consent? Well, it has to go to that specific issue, right? That's the issue you're offering it for. That's what it's relevant to. It has to be material. How does
Correct.
it make it more likely in the second case that the assault was done without consent? Or is it just so, I mean, otherwise it's sort of this general idea that he's a bad person who commits these types of crimes, right? He rapes women in this area in this time frame, therefore he's more likely to have raped this woman, right? I think that's what we're not allowed to do. You agree?
Correct, but in this case, the defendant was claiming that it was consensual. He argued that in the closing argument. He alluded to the fact that the victim may have gotten in the car. The victim got in the car voluntarily and was smoking crack. So he alluded to the fact that maybe she consented to the sexual encounter when she was under the influence of drugs. So if the defendant is claiming non-consent in this case, and the victim is claiming a violent sexual encounter, and then if we have another victim coming forward that's also claiming that she was raped, then that shows that goes to the argument with the doctrine of chances too, because when
leave
you have
that aside for the moment. I'm just trying to understand how your common plan and scheme theory, how it supports intent in a way that is different or other than just showing that he's a person who commits, he's a bad person. He commits crimes like this, so therefore he's more likely to have committed this crime.
Because under the common scheme or plan theory, we have another victim that's coming forward and saying that she was also, defendant also raped her. She didn't consent. We have other similarities, the isolation.
So that would show that we know he would do something like this, right? I mean, that goes to his character, right?
Well, the common plan it goes to showing the intermediate inference of the intent, and it makes it more probable than not that the victim in this case did not consent, because the defendant did the same thing before. He isolated another woman. He took the other woman to a location. He forced vaginal intercourse against her will. He used a weapon in both assaults. All of that goes to proving the similarity of the plan, goes to proving his intent, which was to isolate the women and to rape them. So as long as there is some probative value that it does make the fact that we're trying to prove more likely, which the fact that we're trying to prove is non-consent, then the general rule is the evidence comes in under 401 and 402, and it comes in with a limiting instruction. And that was done here. And then the safety valve is in MRE 403, the probative versus prejudicial test. So that's the general rule. That the rule 404B is a rule of inclusion. So as long as we show the relevance, then the rule is the evidence comes in with a limiting instruction.
Okay, thank you, counsel.
So I'll move on now to the doctrine of chances if there's no further questions.
Well, let me ask everybody else if they have some. Okay, Justice Bernstein,
No questions.
Justice Clement,
No questions.
Justice Kavanaugh,
No questions.
Justice Markman.
No questions.
Okay, you may move on to the doctrine of chances or whatever else you want to move on to.
Okay. I just wanted to mention this, going back to the common scheme or plan. An example would be maybe where the evidence was not similar enough would be in the Crawford case, where the defendant had been charged with a drug offense and the drugs were found in the dashboard of his vehicle, and he was claiming that he didn't have knowledge that the drugs were there. His wife had testified that he had just gotten the car, so he didn't know what was in it. So in that case, they presented evidence that he had been engaged in another drug transaction in the past, and it wasn't similar in that it wasn't another case where the drugs were found in a car, and it wasn't similar enough in that case because he was claiming knowledge, and he did have some evidence that was plausible in some way because his wife testified that he had just gotten the car. So in that case, the court found it wasn't similar enough, and that makes sense in that case because if the drugs in that case in the prior offense would have been found in the dashboard, it would have been different. That would have shown that then you could say like, oh, he did this before they were in the dashboard. He claimed he didn't have knowledge and now he's doing the same thing again. They're in the dashboard again. Then it would be sufficiently similar to show the knowledge. So that kind of explains it better, I think, as far as common scheme or plan evidence. So here, under the doctrine of chances, the degree of similarity required, it's another method of proving the defendant's intent. So under the doctrine of chances here, we have not one, but two victims coming forward claiming to have been violently sexually assaulted. And there just has to be enough similarity in order to make it relevant. So, and a good example of this would be the lottery example where in Maryland, it's in the case US v. York. When someone wins the lottery once, they're envied, but when someone wins the lottery twice, they're investigated. So even here, just even having two events here, it's out of the ordinary because I don't think any one of us has ever raped someone. And so even just having two women come forward and say that the same defendant has raped both of them, that is probative. That shows that his intent, that goes towards his intent. The relevant standard is very low. So as long as it goes towards making that fact more probable, then again, the standard is it comes in with a limiting instruction. So we don't need a lot of similarities in this. We don't need a lot of events in order to move to admit the evidence under the doctrine of chances, because what we're only offering it for the intent. We're not offering it to show the defendant's identity. If that was the case, we would need it to be much more similar. We would need some kind of distinguishing characteristics to show that it was the handiwork of the accused, and in that we need much more similarity and many more incidents under the doctrine of chances. But in this, we're only offering it to show his intent, and it does have probative force, just the one incident, to show that the victim in the instant case did not consent. And then as we cited in our brief, So in the Nicholson case that Justice McCormick wrote the concurrence, and I cited it in my brief, it was 2 armed robberies, and they were offering the 404B evidence in order to show the defendant's identity in that case. And in that case, Justice McCormick reaffirmed the principle that it would be, if they were only offering it to show a common scheme or plan and not to show the defendant's identity, then the striking similarity would not be required. And Justice McCormick said, to establish a common design or plan, it is not necessary to show either distinctive and unusual features or a high degree of similarity between the charged act and the other act. So, but because in that case they were using it to prove identity, then they had to consider the striking similarity. So if the court does find error, then the Luckady test applies, and the defendant would have to show that it's more probable than not that this was outcome determinative, and the defendant cannot meet that burden. The victim in this case, if you believe her testimony, it proved a violent sexual assault. She went to the hospital via ambulance. She had visible injuries. She had an injury to her head from being struck with the bat. She had abrasions. A person that came to the scene said that she was distraught after the incident. She told the police that she defecated on herself. The police found fecal matter at the scene. All of the evidence, all of her testimony points to the fact that this was not consensual, despite the fact that maybe she did get in the car voluntarily to smoke crack. It doesn't make sense that this was consensual if you look at all of her injuries and if you look at the other testimony.
Ms. Summers, thank you so much. Your time is up. Thank you. Mr. Branch, any rebuttal?
A little bit, Judge, thank you. To the extent I understand that argument, it makes me think of a quote that we always use from Watkins versus Chamberlain. That's a Michigan case, saying the major function of MRE 403 is limited to excluding matter of scant or cumulative probative value dragged in by the heels for the sake of its prejudicial effect. So if I understand what the argument is that they're only using it to show intent. And by the way, he goes around with a knife raping pregnant ladies. Now, if the argument is that it's automatically, period, admissible, that is not correct, as Watkins tells us. But also, if you look at Van der Layet, I'm never sure how to pronounce that, it lays out certain obstacles that have to be overcome before this evidence is accepted. And one of them is simply that the probative value of the evidence is not substantially outweighed by unfair prejudice. Then finally mentioned was Crawford. And look what Crawford says. In order to ensure the defendant's right to a fair trial, courts must vigilantly weed out character evidence that is disguised as something else. The logical relationship between the proffered evidence and the ultimate fact sought to be proven must be closely scrutinized. So the mere fact that the prosecution can bend over and say, well, this was to show intent, doesn't automatically say that you can use this if it in fact appears to be character evidence or propensity evidence, and that's what it is. That was when you say intent to have sex, to rape a woman, but even that is heavily going towards character and propensity. Again, this evidence should have been excluded. We're bending over backwards here to get character or propensity evidence and disguised as something else. Thank you.
Thank you. Are there any additional questions for Mr. Branch? Thank you, Mr. Branch. Thank you, Ms. Summers. The case will be submitted.
Thank you.